You are still watching Signature Morning, and we are back still on the conversation of Bright Ngene. We're going to be looking at the legal implications of the Labour Party candidate who won the by-elections from prison. With me in the studio this morning is Barrister Nwabueze Ugu. He's a constitutional lawyer and activist. Thank you for joining us this morning. Good morning.
Thank you, our viewers.
Yes. So now looking at this issue of Bright Ngene, I mean, convicted by magistrate court, sentenced to 7 years in prison, and he contested and won the by-election. So is there any legal framework in Nigeria regarding the eligibility of a person serving a prison sentence to contest and win an election?
The law says, in respect of the House of Assembly, Section 106 of the Constitution deals on qualifications. What is it that will qualify a human being to contest election to the House of Assembly? Very few things. He has to be 21 years or above. He has to be an undischarged. He has to be a citizen of Nigeria, has not acquired the citizenship of another country. He has to have his first school living certificate, and a few other things. But Section 107 deals on disqualifications, things that will disqualify somebody from contesting for election to the House of Assembly. And when you look at that subsection 1, I think it is paragraph C, says that if somebody was convicted of, was sentenced to a term of imprisonment, death sentence, handed a death sentence, or convicted for a crime involving fraud or dishonesty, that such person is not qualified to contest unless, I think it's subsection 2, that says that if there is an appeal pending in respect of that conviction, that the provision disqualifying that person will be inoperative until the appeal is either concluded, or the appeal lapses, or the appeal is discontinued, whichever one is earlier. Then the provision disqualifying such person will then become operative. So outside that provision will stand at akimbo and wait. And that's what is happening in respect of a Bright Ngene, because he has been convicted of a crime involving dishonesty, but he has an appeal pending before the High Court, and that appeal is still pending. And so, because the appeal is pending, he cannot, it will not, the provision disqualifying such person will not operate until the appeal is discharged.
Okay, so what then are the legal implications of him winning the election from prison?
The legal implication, there is honestly no legal implication. If you know that he was convicted of that offense after the election for which he stood had commenced, and the election hadn't been concluded, but because there was a runoff declared by INEC, some wards or some polling booths, I'm not very certain, was inconclusive, and needs to be concluded. So that's why I'm not sure he has taken his oath of office. So now that was after this thing took place, was the time he was now convicted of the crime. And the implication now is that he's still not disqualified until the appeal is concluded. Now, the implication of him winning election while in prison is that the prison sentence cannot wait because it's not a suspended sentence. I'm speaking legally, I'm speaking purely on law, no sentiments attached. The prison sentence cannot wait unless it's a suspended sentence. It's not a suspended sentence. And so the election, his election to the House of Assembly will not override the prison sentence that he's serving. I think that for now, all that will happen is that our hands will be standing at akimbo, waiting for the High Court to determine the appeal.
Which brings me to ask, since he has won this election while still in prison, what then happens to the people that he is representing or the people that have elected him? Because if an elected candidate is unable to perform legislative duties due to incarceration, what then happens to the seat?
I am not sure that this is the first time it's happening. In any event, first and foremost, to answer your question directly, is that the law did not make any provision for what happens. There is a lacuna, it appears. There seems to be a lacuna because the law did not provide for any such thing. Right now, the people of that state constituency are unrepresented. Their voice is not heard at the State Assembly. The implication again is that as far as legislation is concerned, they don't make any input. But then, like I said earlier, the law did not make any provision for such didn't envisage such a situation. Because if the drafters of the Constitution had envisaged such situation, they obviously would have made provision for it. But then, looking at the provisions of Section 107, like I said, it's still, it cannot, nobody will say that he has to leave the prison walls and go and do that, represent his constituency. So the implication is simply that the people are not represented, and there's it's also not possible to put somebody else there. INEC,
no representative of any sort.
No representation, and INEC cannot even, nobody can declare a seat vacant unless probably, yes, it's also provided by Section 109 of the Constitution that after, if the person does not sit for, I think, 2/3 of the period, that his seat could be declared vacant. And now that the election, the election was inconclusive, but right now that the election has been concluded, if probably he doesn't occupy his seat and attend a plenary for, I think, 2/3 of the period, his seat may be declared vacant by the Speaker of the House. And if it is so done, then INEC, the Speaker, will send that declaration to INEC, and INEC will have no alternative than to conduct another election to fill that vacant seat.
Okay. Now, you mentioned a lacuna in the Constitution concerning a scenario like this happening, and you've also mentioned that it has happened before.
Yes,
so
yes.
How come the lacuna is still there?
Well, that the procedure for lawmaking is very Herculean and alchemical. It's not very easy. It's not a thing that is so fast. And you are not talking of the Constitution. It's not like every other law. If you are amending the Constitution, that part of the Constitution will be amended by Section 9, subsection 2, through the provisions of Section 9, subsection 2 of the Constitution, requiring 2/3 members of the National Assembly and 2/3 the votes of 2/3 numbers of state houses of assembly. So if they approve, that is, if the National Assembly begins that process, and then it's approved by this ratio of persons that I've said, then, and the president assents, unless the president's assent is vetoed, then it becomes law. So, but for now, that's the stand of the law.
So do you think that this case blurs the line between criminal law and electoral law, seeing that, how does it reconcile the situations where a criminal conviction intersects with, electoral victories?
Well, there are two broad divisions in law, very broad. There are one, crime, the law of crime, and then two, civil law. Election belongs to the realm of civil law. And of course, like you know, criminal law cannot be halted by anything whatsoever. Criminal law takes precedence. In fact, the Administration of Criminal Justice Act 2015, and even the various Administration of Criminal Justice laws of all the states makes it very clear that you can't even stop any criminal process from continuing, either by the fact that you have gone on appeal or that you bring judicial review against any such procedure. That will not punctuate the process of criminal adjudication. So you can see now that yes, there seem to be some measure of conflict between the electoral process and criminal adjudication, because right now nobody can represent any constituency, state or federal, from prison. You can't, because there's no prison no correctional center that has the authority to bring somebody from correctional center to any legislature to come and represent his people and go back. You can't. The laws of this country has not provided for such a thing, because when you are incarcerated, and that is it. Now the criminal law will have to take precedence, like I said earlier. Whatever is the aftermath of an electoral process will not override any conviction done by any court of law, be it a customary court. Even if there were to be a court of law that is lower than the customary court, it will still override even an election to the office of President of Nigeria, because that one is subservient to whatever is the outcome of a criminal proceeding. And like I said earlier, such thing had happened earlier. If you remember, there was a senator who was elected while he was in prison. I think it was during Obasanjo's time. I've really forgotten the name of this senator. He was elected while he was in prison. And that election was not quashed because he was in prison. And the fact that he's in prison didn't stop him from being elected. And so right now, and of course in this instance, you know that the election had been done while the man that was contesting was very free. It's just that it was inconclusive. But it's also important to say this, that even if the election had been concluded and he had taken his oath of office and oath of allegiance and was now properly in the State Assembly, that still would not have stopped the criminal proceeding from going its full hog, and it also wouldn't have stopped the court from giving a verdict. But remember that, like I read this morning from somebody who described himself as the former legal advisor of that community. It was an Arise television interview. He did say that the criminal charge was started in 2017. So he was charged in 2017, and I think he took plea in 2017. And the matter had been going on, but hadn't been concluded before even the current, before even he stood election. Because this election was done in 2023, January, I think, 2023 or February. And this thing started in 2017. So,
exactly. Now, aside from the law, I'd like to get your personal opinion about the entire case of Bright Ngene, because there have also been protests asking for his release and the like. So, aside from the law now, you as a person, what do you think about it?
What I think about it is that first and foremost, I've heard a lot of persons say the government is the hand of Esau and the voice of Jacob. But I honestly have not been able to come to terms with that, because first and foremost, I know that the governor, accusing fingers have been pointed at the governor, but I know that the governor is a lawyer, and I also know that all through the time he's been there has been too many occasions where I was directly involved, and ordinarily he would have liked to, like some governors in Enugu State, previously in such situations would have gotten directly involved. In some case, he never did, either by phone call or by sending a mystery or anything. And these were things concerning the state, things that should be of interest to him, things that he should ordinarily want to intervene. He didn't intervene. And if you look at this matter, this is a matter between the community and the man incarcerated. It's unfortunate that he's a lawyer. I'm not happy about it. If there was anything, if I knew of such thing, I would have probably intervened before the conviction to ensure that it doesn't take place. Well, right now, there's a conviction. But one thing that appeared to be clear to me is that the government has no hand in it. Because, there is no way, this is not a matter that started after Mba became governor. This is a matter that started before Mba became, in fact, before even the second election of Ifeanyi Ugwuanyi. Ifeanyi Ugwuanyi was elected the second time in 2019. But this matter started in 2017. So this government has no business with it. Now, the people the complainants are still alive. I understand that the complainants are the two traditional rulers there, and the two prime ministers, and I think PG, either one of the PGs or two. These are people that are alive. They are not dead. They are still alive. And obviously, they also come to court. I can't honestly make out the fact that I can't see how the government would be said to be involved in such matter. And nobody has said that any of the complainants have backpedaled. Nobody has said so. And of course, you know that in such a matter, the complainant is the Commissioner of Police. Those complainants are said to be fictional complainants, the people who made the initial report to the police. But of course, if I am also not certain that the police was averse to peaceful settlement, I don't think so. But then it will not be correct for anybody to tell the police to put in a notice of discontinuance, to withdraw the charge, when the complainants, the fictional complainants, were still very much interested. What reason will you give to them or to anybody to withdraw that charge? So I think that first thing must be done first. Let the people settle. Let the community, the people who are in this whole game. I also understand that some lawyers had intervened before now, and yet the warring parties could not settle.
Yes, well, Barrister Nwabweze Ogu, we're going to leave it here for now because we are out of time. But thank you so much for joining us.
Thank you, my sister. Thank you, our listeners.
Yes, and with that, we've come to the end of our show this morning. We had quite a number of interesting conversations for you, and we hope that you enjoyed them as well. Well, I am Uchenna Chimdi Oluoha, and have a good day.
Signature TV, news in your pocket.